Okay. So here I am reviewing on the topic, the nature and sources of law. Before going to the topic, we can go through the concept of jurisprudence. That is, it is a theoretical study of law, and the term jurisprudence is derived from the Latin word jurisprudentia, which means the knowledge of law, where juris means law and prudentia means the prudence or knowledge. As it is considered as a knowledge of law, it may be acquired from the sources, constituents, functions, purposes, limits, relations, etc. So the knowledge is acquired through questions and answer method, and the ways for such acquisitions are by observations, philosophical reflections, inferences, etc. Then moving on to what you meant by law. Law is a uniform rule of conduct and human relations. Then we are looking into the nature of law. That is, it is a general rule of human behavior of the state. It is as per the will of the state, and it creates binding and authoritative values for all people of the state, and thus it is a command of sovereign. So these all are the nature of law. And as we are going to the schools of law, there are mainly 8 schools of law. They are the natural law school, positive or analytical school, historical school, sociological school, realistic school, critical legal studies, Marxist school, and feminist school. So we can discuss it one by one. First one is the natural law school. The main supporters of this school differ in different periods. In classical period, there is Socrates, Aristotle, Plato, and in medieval period, there is St. Augustine and Thomas Aquinas. And finally, at modern period, there is Leon Fuller. This school focuses on the relation of law to certain ideals which law is meant to achieve. They seek to investigate the purpose for which a particular law has been enacted. To them, law is the product of human reason and it must be according to morality. So these all are the thing about the natural law school. Then the second one is the analytical or positive school. The chief exponents are Bentham and Austin. It considers law as it is and not as it ought to be. Austin is the father of this school, and this school is also called as the imperative school, and it treats law as a command of sovereign. Austin separated the morals and religion from definition of law, and his viewpoint was on 2 principles, that is, law is the command of sovereign, and second one is the force is the essence of law. That means what cannot be enforced is not a law. That was the thing about the Austin. And this school provides that law must be made by the state in the interest of general welfare. These all are the thing about the analytical school. Then moving on to the historical school, Sevigny, Sir Henry Maine, Edmund Burke are the chief jurists. They believe that law is an outcome of a long historical development of the society, as it is originated from social, custom, conventions, religious principles, economic needs, relations of people. According to this theory, law is the influence of the past. It supplements analytical school of law. And the next school is the sociological school. Montesquieu, Auguste Comte, Herbert Spencer, Duguid, and Roscoe Pound are notable jurists. They treat law as a social phenomenon. They stress on the functional aspect of law rather than on abstract contents. According to them, law is an expression of human society concerning external relations of its individuals. And as we are moving to the realistic school, the supporters are the Oliver Wendell Holmes, Jerome Frank, Olive Crona. They think that there can be no certainty about law as its predictability depends on collection of facts decided by tribunals. They stress on psychological approach, and the importance of legal terminology is opposed by these realists. They prefer to evaluate any part of law in terms of its effects. And the next school is the critical legal studies. According to this, law is the one which is to be looked through critical studies, and the law should not be viewed as it is, and it must be criticized for forming a law. Then, as we are going to the Marxist school, Karl Marx and Friedrich Engels are the founders. According to this, a desired system should be a communist society based on rational planning, cooperative production, and equality of distribution. It is to be liberated from all forms of political and bureaucratic hierarchy. For Karl Marx, law is nothing more than function of economy without any independent existence. And as we are the last school, but not the least, feminist school. According to this school, law in constructing, maintaining, reinforcing, and perpetuating patriarchy, and it looks at way in which patriarchy can be undermined and ultimately eliminated. As we come to the end of the schools of law, next moving on to the sources of law, that is, there are mainly 4 formal sources of law. They are the legislations, precedents, customs, and the conventions. First one is the legislation. Legislation which are called as the statutory law. Legis means law and latum means making. There are mainly 2 types of legislations, that is supreme legislation and subordinate legislation. The first one is the supreme legislation. It is the one that proceeds from the sovereign power of state. That is, example, the acts, statutes, etc. Then the subordinate legislation, it is the one which proceeds from any authority other than sovereign power. Its continual existence and validity will be dependent on some superior authority. Example, we can say that the colonial legislation, then the executive legislation, judicial legislation, etc. There is also one more legislation, that is the delegated legislation, which is also a part of the subordinate legislation or a type of subordinate legislation. Then there are several problems in the legislation as a source. The one is of interpretation problem. When we interpret a law, there may be problem due to ambiguity, vagueness, etc. This can be solved by different principles like the literal rule, golden rule of interpretation, etc. So moving on to the source of case law or precedent, we know that judgments rendered by Supreme Court are binding on all subordinate courts, high courts and tribunals within the territory of country. In case of judgment rendered by High Court, it is binding for all subordinate courts and tribunals. Then there are mainly 3 kinds of precedents: declaratory precedent, authoritative precedent, and persuasive precedent. When we are looking into declaratory precedent, the judges do not create or change law, but they declare what law has always been. Authoritative precedent means judges must follow precedent whether they approve of it or not. Persuasive precedent means judges are under no obligation to follow, but they take precedents into consideration. So, the next source is the custom. Custom is a traditional and widely accepted way of behaving or doing something that is specific to a particular society, place, or time. The ingredients which must be followed are the antiquity, continuous in nature, peaceful enjoyment, obligatory force, certainty, consistency, reasonableness, conformity with statutory law. So these ingredients must be there to become a valid custom. There are mainly 2 broad classifications for customs. That are customs without sanction and customs with sanction. Customs without sanction means customs which are non-obligatory in nature and are followed because of public opinion. And the customs with sanction means which are binding in nature and are enforced by state. They are further divided into 2. That is the legal custom and the conventional custom. The first one is the legal custom. Legal custom is the one whose authority is absolute. It is recognized and enforced by courts, and the legal customs are further classified as the general custom and local custom. General custom are the one prevail throughout the territory of state, and the local custom means customs applicable to a part of the state or a particular region, etc. The next custom after the legal custom is the conventional custom, which are binding on the parties to an agreement. Then moving on to the last formal sources, that is the conventions. This is a law arising out of an agreement between parties or rules made by any institutions. The rules under it are for regulating the conduct of members of particular body, institutions of business. The agreement may be between the individuals, between the nations, between the individual and group, or between the groups. Example of the conventions, we know that it is Convention on Rights of Child, Geneva Convention, etc. Then coming to the end of discussing that the informal sources of law. They are the treatises, legal periodicals, legal encyclopedia, law commission reports, and legal dictionaries. The treatises are single or multi-volume works dedicated to the examination of an area of law. And the legal periodical articles are in-depth discussions of narrow areas of law and legal issues. And the legal encyclopedias means the immense sets of books that brief by describes all the main legal issues for a particular jurisdiction. Then comes the Law Commission reports and the legal dictionaries for the informal source of law. And these all are the concepts and areas that are coming under the nature and source of law. That's all. Thank you.